Well, this discussion will deal with topical issues of the construction business, which is a very interesting area of human endeavor. We'll try to address it from various angles. With that view in mind, purpose in mind, we have invited participants of our roundtable discussion who represents various walks of life in the construction business, banking community in particular. We have the pleasure of Mr. Pavel Kosov, who is the Senior Vice President of the VTB Bank, who will address a number of issues relating to the financing of construction contracts. He will tell us about the various schemes available for financing constructions. He will tell us about the issues which this section faces. We also have invited representatives of large construction companies. In particular, Galina Volchevskaya represents one such company. She is a deputy executive director of the LSR construction company. She will tell us again about the way they solicit the funds of individual investors, physical persons, to finance the construction of the housing, and she will tell us about the way they address those issues and what proposals are available. Then we have also invited to be part of our meeting a representative of the Federal Fund of the Support of Construction Industry, Housing Construction, Sirotin. He will tell us about the activity of these funds. He will tell us about the way they are addressing those issues. We also have the pleasure of the Fresh Fields company, Mr. Thomas Vale, who represents the arbitration group of that company. He will be telling us about the ways the commercial disputes can be addressed in arbitration courts, which deal with the construction contract disputes. And then we have a representative, a colleague from China, Xiaopeng Wang. He is a partner in the Grendel law firm. He will tell us about the issues which the Chinese construction sector faces in China. He will be one of the last speakers to address the audience, and he will have the chance to summarize previous speakers' utterances. I will act as a moderator. My name is Olga Kudryavtseva. I am the lawyer responsible for the construction sector in the law firm Ivanov and Partners, and I will moderate the discussion so that we should be able to discuss as many interesting issues as possible. With your permission, we will kick off the meeting, and I invite Pavel Kosov to take the floor and to tell us about the financing of construction projects, what issues we have today, what schemes are available today.
Спасибо за интерес, проявленный к нашей дискуссии. Я действительно в своей... Тут есть презентация, я в ней достаточно подробно остановлюсь на основных принципах, из которых исходит банковское учреждение при финансировании строительных проектов. Понятно, что ни одна стройка без финансирования не обойдется, поэтому тема действительно достаточно важная. Значит, если бы еще заработала волшебная палочка, было бы замечательно. Не работает.
Так. А вот не работает у человека система вот эта.
Можно как-то переключать это? Да, собственно...
Okay, thank you. So the key standards that banks use while financing construction projects are as follows. Any initiator of any deal, whether it is a deal in the state or a state or any other, should show to the bank, prove to the bank that it is interested in seeing this project through. It should participate with its own funds. So the banks, the metric is such that we always want that investors should participate in the financing to the level of at least 15-30% of the total cost of the project. And it goes without saying that any project can be supported with all the requisite legal documents. They should be in a place. All, say, land permissions or land permits should be available at the final stage. All permits, all approvals should be there, enabling the constructor to start the construction works. That means that banks would be prepared to take the risk and to allocate funds for the project even before all final approvals are available, fully understanding that the legal, say, procedure will go on and certain steps will have to be covered, and then all the permissions, all the permits will be there, and then the banks will be able to start financing. The economic effectiveness of the project, the feasibility of the project always is very important. We study every proposal in great detail. I will later be speaking at length about those things, but meanwhile, I would like to say that we definitely look at the ability of the borrower to service the debt, ability to pay the say the interest at the stage, at the phase of the construction phase. The financial model is also looked upon. It correlates with the feasibility of economic effectiveness. We look at the way the financial model correlates with the market situation. Prior to the crisis, we used to accept as a proof or confirmation of a business model the opinion of expert companies, independent assessors, or any other similar organizations. Now we understand that, unfortunately, these days, they were not done correctly. A lot of errors were committed. We did not pay enough attention at that point in time, and certain negative consequences had to be borne by us. They were not tragic, but nevertheless, they were undesirable, and we had to resort to some adjustments. So as a result of the crisis, we in our organization, our bank, opened what I call an in-house marketing department. We have our own market experts who look at each project from A to Z. They look at every single aspect of the financial model. On top of marketologists, we have the benefit of construction engineers who understand what construction is all about. They understand how all the elements of the construction process come into interaction to understand the cost of the project. And it's obvious that it's not a secret at all that any contractor wants to get the maximum benefit from a contract. That's why assessors should be attentive to the budget for the construction which is proposed, and to control the actual spending against the approved budget. And that means that just the construction engineers from our marketing department often visit construction site and send signals to us, to bankers, so that we can continue or suspend financing depending on the situation on the construction site. Then we have the guarantees of the final beneficiaries, which is one of the most important requisites that correlates fine with the first condition that the investor should participate in a project with its own funds. I should say that many people are shy to give such guarantees, but we try to negotiate such thing. And then the pledge of the interest of all the participants of this project is also a condition. What are the conditions, terms and conditions for finance? Let us look at the project financing in the way as we look at it. This is it a loan? Is it a credit line with a limit cap on the, say, availability of funds? The tenure, which I showed in our presentations, are the most typical one. That does not mean that they are the only, say, a number of years available, 7 years. It goes without saying that this is something which can be negotiated, but 7 years is not the limit. We can speak about 10 years in terms of a tenure. We can speak of any, say, time. If the project is good, we can even provide financing for a longer period of time. Commercial real estate with the follow-up sale. The construction takes 2 or 3 years, then the renters will move in another 2 or 3 years, so 3 to 5 years. Sale of commercial real estate, unless we speak about huge territory development where large development is there. But in any case, we will speak about the credit line with a limit for availability of funds. Every credit will not be more longer than 3 to 5 years, because the turnover of housing is faster than that of commercial real estate. Use of loaned borrowed funds is possible until the moment when the object is commissioned, because the commissioned facility does not require any additional financing, only for the maintenance, which is done from the source of the current. So the key sources for repayment is the revenue from the operations of the facility, sale of premises and the facility. As far as the repayment of the principal is concerned, the schedule is drawn according to the business plan, which is provided at the beginning of the negotiation process. We agree to this payment process, payment schedule. Obviously, we provide for a grace period for the investment phase. I would like to invite your attention to the fact that if a year ago we could allow to the borrower to repay the loan interest in the only the third year of the loan agreement, now we are no longer in a position to allow ourselves this luxury, though the central bank instructions issued instruction saying that any loan can be served on an annual basis, and if it is not serviced, the bank is supposed to create provisions, and creating provisions for a bank is one of the most unpleasant thing it can do. That is why, unfortunately, we have to think our financial model in such a way and to coordinate it with our clients so that they should be in a position to start servicing the loan in the very first year. We still try to accommodate their wishes. They have to repay at least 2/3 of the interest rate of refinancing within a year. At least 2/3, then the bank will not have to make provisions for such loans. Well, the revenue from the sale of premises in the facility is not early repayment of the loan. If we are not talking about construction, but talking about any regular production, early repayment can be easily calculated, and the commission can easily be also calculated. In our case, real estate is one of the most difficult items for financing, and that's why any early repayment is fine, but we will not charge anyone for early repayment. The financing of constructions is somewhat complicated, but in principle, I think it's clear. This is the scheme of financing of housing construction. It was invented 4 or 5 years ago, and frankly speaking, it was invented in our organization, our bank, in VTB. Right now, it is widely used by all our colleagues and our competition, almost all our competition, because we believe that the optimal scheme taking into account interest of all participants in the process. It is based on the federal law number 114, which regulates relations between of developer and investors. The bank cannot directly take land as a pledge, as a collateral when construction housing, because in the process of implementation of the project, the developer starts to sell the flats. The final beneficiary, within the to the extent of the payment, will have the right to the part of land upon which a house is constructed. That's why we use a different model. The developer and developer also functions as an investor, creates a subsidiary which is called an investor, which enter into with the developer in an investment contract under which they buy from the developer square meters, and then this SPV places this say land as a collateral to the bank, and then financial resources are made available by the bank via the say subsidiary based on the acts of completed work. So the construction process is financed. The square meters are with the developers. Only those square meters, go to the bank as collateral to enable the bank to issue funds to the negotiated extent of the financing process. And that's, in a nutshell, everything. Perhaps I should also mention that at the moment of sale of square meters to the final buyer, to individuals, if 100% of the price is paid, and we see that 100% of this flat apartment goes to the bank, or we understand that 100% of the volume of the agreement on the shared participation has gone to the construction, we can freely say release from the pledge collateral a specific flat, and we'll give to the final recipient, final buyer, the say contract for the shared participation, and we no longer have any relations with that particular final beneficiary. We continue to work with our developer. Speaking about the supervision, I would once again want to say the same bank department monitors the situation on a daily basis. They make photo reports, and quite often we request developers to install a web camera on the construction site, so we should be able to monitor the situation on an ongoing basis. I'll be definitely pleased to take any other questions. In terms of the commercial real estate, situation much easier. We don't have any additional agreements. We take land as collateral. And we finance the developer directly, and the situation is same. We finance only to the extent of the acts of completed work. We provide monitoring and supervision. So providing financing to for the construction of commercial real estate is much easier than with the housing construction. However, we understand, of course, that the economic category of housing is very much in demand these years, but the commercial real estate is something which is harder to sell. That's why we should pay more attention when analyzing the project. May I also invite you spend a couple of minutes speaking about the involvement of public money and individual investors' funds in implementing civil construction projects. Involvement of the public money is feasible when you create infrastructure, you realize construction infrastructural projects like transportation nodes or technoparks or innovation centers. And I mentioned that in my presentation, but in large projects of territory development, participation of public money is also feasible. At least an attempt can be made to solicit such public money with a view to develop engineering, communications, utilities, and other facilities. It's also there. You can find it in my presentation. We have accumulated experience of such kind within the PPP partnership. A few years ago, we entered into the Slavyanka project, which is not far from here in St. Petersburg. We bought out a piece of land. We approached appropriate government authorities with a request to provide co-financing for the preparation of development engineering facilities, and this project is going just fine. We're very happy to see that. In terms of the attraction of funds of individual investors, physical persons, the law, federal law 414, provides a legal foundation for that. Some companies, until this moment, use certain preliminary, say, contract sales and buy sales contracts. We no longer use that. We use only the facility provided by the federal law 214, and under that law, all say interests of the developer are protected, and the interests of the final buyer are also protected under this law. Within our frame of our relations with the borrower, bank is also interests are also taken care of, and the borrower feels quite comfortable because he sees the money of the bank, he sees the final buyer. This is a very good law. It was adopted about 2-3 years ago, I think. Yeah. So we're quite happy. We're quite happy with that particular piece of legislation. And initially, I remember many were reluctant, but now I think all understand that there is no alternative, and this is the right way to do. Well, we decided not to address. I want to thank you for your patient hearing, and would like to believe that I have not taken too much of your time. Thank you, Pavel, for your very, substantial presentation. If there are any questions to be asked right now, you're most welcome to ask those questions. Kindly use microphones at all times. Now in the market you will see financings via, mutual funds facility. Do you consider as an option the pledge of, share in the mutual funds? No, we do not do that. But so far, no one has yet approached us with this proposal. But so far, we use mutual funds. We have set up several closed mutual funds where you will have our facilities. The participants in that mutual funds are bank and some of our, financially related organizations. But perhaps we should think about this, what you say. Any other questions from the audience? So far, none. Okay, I want to ask more question myself. Well, now we see the development of such leasing of real estate, which leasing companies are developing, and they sort of offer it as an alternative to traditional forms of providing collaterals to the loans, like mortgages. So they make it to look as an alternative to regular loans. Is it a real alternative, which is a competition, a growing competition for the bank, or is it just another form of financing which has its own drawbacks? It's a very good instrument by itself. It is an alternative. In fact, it is no much different from the standard Lombard crediting. There are upsides in this approach. The person who is interested in this project becomes the owner only when all the leasing payments have been paid, and the a term of payment may be 15 years or whatever, and the lessor, until the moment when the facility is transferred to the accounts of lessee, continues to be the owner of the facility. What is the upside for those who want to buy a facility under a leasing program? This person is freed from payment of the property tax, and I do not remember exactly from the standpoint of accelerated amortization, is it there or not? Only 6 months ago, that was a subject matter heatedly discussed, I remember. Maybe now it is still there, but there is still an opportunity for making an option in favor of the accelerated amortization. So in 15 years from the moment of the contract, the lessee gets the facility facility without, at a lesser, say, book value, which is a positive phenomenon for him. In terms of participating with your own funds, there is not much difference, because lessor would definitely require participation with own funds from lessee, and the requirements are not much different from those of the bank. But in real fact, basically these are the two faces, one of six or half a dozen of another. A Lombard credit or leasing agreement look very much alike. And there are positive upsides, as I said, absence of the property, say, tax, and the period for repayment is long. And if we still have this option for accelerated amortization, it's also positive. It's an upside. Okay, let us now go on with our agenda. We have a number of interesting subjects. I'd like to request Galina Volchevskaya, who will be telling us about the ways that funds of private individual investors can be accumulated to finance the housing constructions. We all remember well that the federal law about the participation in the, say, shared construction leaves three legal forms for the attractions of funds. By entering into contracts with the contracts.
Ценных бумаг в виде жилищных сертификатов, и это посредством создания жилищно-строительных кооперативов либо участия в жилищном накопительном кооперативе. На практике работы нашей компании можно рассмотреть в сущности все три формы участия граждан в строительстве, поскольку они либо применялись с нами, либо применяются, либо, по крайней мере, рассматривались. Ну, основная форма, которую в результате мы выбрали, это, естественно, посредством заключения с гражданами договоров о долевом участии в строительстве, поскольку этот закон максимально защищает права дольщиков, граждане сами предпочитают выбирать именно эту форму участия. И это у нас сейчас основной способ привлечения средств граждан. Выполняется вся установленная федеральным законом последовательность действий застройщика, оформление прав на землю, получение разрешительной документации, публикация проектной декларации, после чего открываются продажи. Что беспокоит в свете выполнения этого закона? Закон родился, как вы помните, не на пустом месте. Более 10 лет на основании первой и второй части Гражданского кодекса, двух законов об инвестиционной деятельности, складывался рынок, складывалась практика привлечения средств граждан. И закон родился с учетом всех ошибок, с учетом промахов, которые допускались в результате спонтанного образования этой практики. Это и двойные продажи, это и замораживание объектов строительства, это и привлечение средств к проектам, которые не были реализованы, это отсутствие у застройщика необходимых документов для того, чтобы граждане могли потом спокойно оформить свои права. И в то время как, в общем-то, закон должен соблюдать баланс интересов застройщика и дольщика, закон, конечно, направлен больше на защиту интересов дольщика. Но застройщик может существовать, в принципе, успешно и получать прибыль в рамках 214 закона, однако последнее время вызывает беспокойство применение к отношениям, возникающим в сфере долевого участия в строительстве, норм закона о защите прав потребителя. Если сразу после вступления в действие закона о долевом участии
the law of the protection of life of consumers were not applicable, but then the Supreme Court was made quite a clear ruling that if the law on the participation, the financial provides for some functions, it will be applied. If not, then the law on the protection of the rights of consumers will be applied. But now the court practice has come into force, and the developer, if the developer does not oblige the individual investor, then the developer will be penalized according with the law. But even within the framework of the participations in the financing, we believe that within the framework of the participation of the in financing, certain number of cases are supposed to be made when a person invests money in the construction, then tries to return funds the money back and then to gain some 50% as penalties. So this is an implementation of the provision for the liberation of funds and to get additional gains.
Going to courts in these cases can be different to dispute against the powers of attorney. Well, fantasies can vary here. Of most concern is the use of Article 32 of the Law of Consumer Protection that enables the consumer to terminate the contract at any time with a reimbursement of costs. Such lawsuits have taken place. Some of them have been won, but if the Supreme Court says that contract can be terminated at any point in time, then this scheme of interest holders' participation in construction can be destroyed. And now, as regards other forms of participation, well, housing certificates. Other than the government sector, in the private sector, they are not being used. We've considered this. However, we rejected it because redemption of housing certificates, the methods can destabilize relations between the constructor and other participants of the process, since the redemption is both by a purchase and sale agreement and the number with the number of relevant certificates and the nominal value based on indexation. This is a security that enables the owner to receive income. So the constructor is interested in building and sell, and the holder is interested to be returned indexed cash. So this uncertainty in the redemption of the certificate that depends on the holder has led to a situation where we have abandoned this method, just as other companies. And finally, the housing construction cooperatives and housing accumulation cooperatives. Well, for the developer, as part of the cooperative, for us, there's nothing special in this. And the housing construction cooperative is a scheme used by many developers because it enables the developer or enabled to raise cash and the cooperative is set up, an investment contract is made with the developer, and they also engaged interest holders who bought the property. This was convenient because it was not as difficult in terms of time. But this is a less protected scheme for the citizens because they depend on the conditions of the investment contract between the cooperative and the developer. There's no formalization in their relations because there are substantial conditions here, and strict timing is set for the handover of apartments, and accidental loss risk is also insured. and amendments were made in Law 214 and the Housing Code of the Russian Federation. As a result, such cooperatives must act as developers. As of today, this approach is used as part of the bankruptcy procedure for housing cooperatives, and on the whole, this can be used more widely if the legislators provide more favorable conditions. And of course, a lot depends on the conditions and how easy it is to obtain loans for the beginning of construction. This is briefly everything I wanted to say, and I will be happy to take your questions. Thank you very much. If you have questions, you are invited to ask them. Oh, no questions? Well, then I have a question. You spoke about the protection of consumer rights and problems with shares. Often the question arises about the quality of housing built by the developers, how feasible it is to use these norms to the quality of real property. Is this law sufficient to protect the rights of the interest holders? I believe that additional guarantees are required not as part of the consumer protection law, but in technical regulation as well, because quality issues are issues about the compliance with construction standards by the developer. So the supervisory authorities should not forget about checking compliance with the standards, something that interest holders cannot do, shareholders. On the other hand, shareholders are protected by the law on consumer protection and interest participation in construction. And regardless of the law, the situation is this, that in court you can prove the fault, whose fault it is if defects are found. Are they a result of non-compliance with construction standards, or it was wrong maintenance of or operation of the buildings? Now, the issue is about sanctions. This 50% fine, if the developer is faulty, the developer will rectify and must reimburse the moral damage. And a 50% fine is exaggerated, I believe. This is what I wanted to say. However, most importantly, this is about the opportunity to terminate the contract and money being paid back. This is an interesting topic regarding technical regulation. There are trends now, and they're talking about the need to harmonize technical regulation with European standards. And there are varying opinions about this to consider the geographical features. So very briefly, what do you think about it? Of course, climate conditions, geographical conditions need to be considered. And houses built in milder climate in the Mediterranean, in the European Union, are not the same as in the Urals and in Siberia. And the concept here used in the law to integrate European codes in the Russian Federation included an adaptation to the geographical and climate conditions, but the issue is that this requires a lot of effort and time. This is done, but not as quickly as one would wish. And as part of the law and technical regulation, companies can develop their own standards in line with the existing technical regulation. This should come from the bottom, from construction companies, and it's even more active than on the level of the Ministry of Regional Development. Well, thank you very much, Galina. If there are no more questions, we will move to the next speaker, Vladimir Sirotin, to continue on the topic, and he will tell us about a few words about this foundation. Well, thank you very much, and thanks for inviting me here. Can you hear me?
Так слышно лучше? Спасибо большое. Я бы хотел сказать, что, конечно же, рассматривая вопрос о жилищном строительстве, мы не можем не упомянуть.
Let me mention the availability of land for the construction business, and in order to rectify the deficit, the shortage, the federal fund for the assistance of housing construction was set up according to the presidential decree in 2008, and it was decided that land would be used as provided by the government and not used for housing purposes, and the fund was set up to oversee the process. Back in 2008, the federal law was adopted to develop housing construction, which established the status of the fund and other issues. The fund, as you well know, accumulates land resources, land plots, not used those who are under the authority of the relevant entities, and they are provided to the developers, and then the foundation is a coordinator and regulator of the entire process, and this is due to the fact that the foundation with all these subjects has made an agreement. So for each land plot, we have a plan of actions to develop the land, including the roles of all the parties to the process. And the foundation sometimes provides financing and provides support to the developer. The foundation also provides insurance 25% of the resources. The foundation, the question was about guarantees of quality, so auctions are undertaken, and the foundation can require the participants to prove they have the experience and relevant permits as required by law, and therefore the foundation scans the companies for qualifications and experience, ensuring the quality of construction. There are other forms for housing construction, like land plot being handed over for free use by the developer, provided that the sales price of housing at such land will not exceed the price established by the Ministry of Regional Development, the so-called Dutch auctions. We've had such Dutch auctions last year. This is a unique example. There's no more similar examples in our law when there's free land provided, and the developer provides inexpensive housing. Then it's handed over to cooperatives, cooperative members. Work is underway to develop rent of housing, then free loans for land plots. The foundation will take part in the financing of infrastructure. The fund will hand over land for other projects. There are mechanisms established in the law to eventually create a relevant class to reduce the construction time, duration, and the cost of housing. We have an example now where the construction cycle within 3-4 years, we have already projects are completed, and the market price has come down by 45%. So the foundation is a regulator here, and its objective is that more than half of the development be done on the free land. This is all I can tell you to start with. Well, dear participants, if you have any questions to Vadim, you are invited to ask now. If not, I will ask a question. You said that the free transfer of land is practiced to housing construction cooperatives. So how can citizens set up such a cooperative? How can you do it and take part in an auction? Well, the procedure is described in the law. There's a governmental decree. There are categories of citizens that can be members of such cooperatives. Usually these are citizens, socially protected citizens, workers of government organizations and institutions, where the foundation takes the land. So land is not just taken from such organizations, but then this land is given back to the citizens who are employees of such government institutions. There is a list of such categories of citizens who can set up cooperatives, and an application is sent, it's considered, and then land is handed over to the cooperative to build housing or to its members. Have you had any instances of abuse? Because such a cooperative can have new members joining it. So citizens that are part of the category could set up such a cooperative and then receive free land from the government, and then dispose of it in any possible way, in any way they wish. Any guarantees to avoid, to prevent abuse in this area? Well, let me say that this is a fairly new practice. We just started doing it last year and this year. We haven't seen situations like that, not yet. But still, like I said, there are categories of citizens entitled to enter into a housing cooperative, and provided that they qualify as part of a category. So housing cooperatives will not accept any citizens not qualifying for a category. But how do you control that? How do you check it? I mean, how can you control the operation of the housing cooperative? It's got to be controlled by the incorporation articles. Well, it's not being controlled. and the citizens, part of category, they are entitled to join cooperatives, and based on that, documents are made and land is allocated. I'd like to ask a question myself. When an investor participates in an auction and wins, if I recall, there's a schedule for a few years for the payment, right? Payment is not done all at once. Yeah, there's a payment period. There's rent installments. Yeah, but the title to land should be paid at once, or how do you do it? Well, the right is paid, the title is paid at once, and then there's rental payments over a certain period of time, and there's a favorable regime so that payments are reduced. But most of the payment is when the developer has completed the construction process and obtains cash from selling it. And land is owned by the Russian Federation, right? Yes, land is owned by the RGS Foundation. Okay, then unfortunately we have a collision here because we try to do it with a bank, but it's very difficult to lend money when you don't even have any collateral as land or something like that. So, I mean, I don't know. Have you ever worked with banks? Yes, absolutely. We have agreements with many lending institutions, but I can tell you that ownership title are issues very attractive, and that's why the foundation was established, because all the land that they cannot be used for housing, and now in our situation, using that for housing, that's the purpose of the foundation. Dear participants, does anybody have any questions? If so, please ask now. If not, we'll move to our next speaker. Freshfields, Buckhouse, Deringer. Thomas Weil will tell us about dispute settlement in the area of investment arbitration. Is my understanding correct? And then Thomas has a presentation, set of slides to show us. You have the floor, please. Thank you very much. I will speak English, but if you have questions in the end, you can ask them in Russian.
Talk briefly about the options for dispute resolution, and in particular about arbitration under investment treaties. I'll cover 4 areas today. 1, what investment treaties are, what they protect, and how they can be used. What investment arbitration is and why it's relevant to construction projects. The scope of investment treaty coverage in Russia and the CIS region, and case examples of investment treaties being used in the context of construction disputes. Investors regularly use this form of dispute resolution when dealing with states. I should point out that in my presentation, I'm focusing on the framework that exists both for investors and states in the construction sector, so that both parties can identify the risks and opportunities that are available to them under investment treaty arbitration. The use of investment treaty arbitration is particularly common in the petroleum industry. In recent years, we've seen an increase in the use of investment arbitration to resolve construction disputes. In this regard, it's helpful to note that there's a significant overlap in the issues potentially faced by companies in both the petroleum and construction sectors. As you'll see on the slide, for example, the underlying contracts for projects in both fields may contain clauses which provide for the application of both international practice or norms and the application of local law, which may result in conflicts. Similarly, disputes in both sectors may arise from the interpretation and application of cost recovery mechanisms. Such disputes often also require the use of experts in order to assist in resolving the dispute. As noted, parties in the construction sector are therefore becoming more familiar with the use of investment arbitration. So what are investment treaties and what is investment arbitration? An investment treaty is an international legal instrument between two or more countries that is designed to promote investment flows between the two countries and to protect the investments made in each of those countries by investors from the other country. Importantly, even though investment treaties are between two or more countries, they protect individual investors. If the company's investment has not been protected adequately, it may be able to initiate arbitration against the government in whose territory the investment is located, even when there is no contract between them. Arbitration under investment treaties occurred infrequently until the late 1990s. Since then, however, we have seen an explosion in cases. Within the last decade, about 200 cases have been filed by investors against states under investment treaties. And many of these cases have led to substantial damages in favor of the investor. This increase in arbitrations is in part due to the large number of bilateral and multilateral investment treaties signed in the last few decades. Investment treaties are one of the tools used by states to increase foreign investment. The majority of these treaties are between two states, and therefore they are called bilateral investment treaties. Historically, these treaties were concluded between capital importing states and capital exporting states, but we're seeing these treaties used more widely today. Some investment treaties are concluded amongst more than two countries. These are called multilateral investment treaties. One example of this is the Acm Treaty, which many of you will know was concluded between a number of countries in Asia, namely Brunei, Cambodia, Indonesia, Laos, Malaysia, Myanmar, Philippines, Singapore, Thailand, Vietnam. So a number of these countries will of course be interesting for investment, and the Acm Treaty is one place to look for a tool for effective dispute resolution. The last two bullets on the slide refer to different sets of procedural rules which may apply to resolution of an investment dispute. Some of you may be thinking to yourselves, it's great that these investment treaties protect my investment, but if something goes wrong, if the state acts improperly, how am I going to sue the state, and where, and what will my remedy be? Well, one answer to that question is ICSID. ICSID is the International Center for the Settlement of Investment Disputes, and it's an arm of the World Bank. It was established to provide a special forum for arbitrating investment disputes. It offers qualifying investors the opportunity to have their investment disputes resolved by neutral tribunals. These tribunals are entirely self-contained and delocalized, meaning that they are independent of local courts and local laws. Most important, the awards of these tribunals are immune from review by national courts, and yet are enforceable in the courts of more than 140 states as if they were national court judgments. Some treaties also provide for proceedings under the Untitled or ad hoc rules, meaning there is generally no administrating authority for the dispute, and the parties have greater choice in the procedure to be applied. One important distinction between these rules and the ICSID rules, which I will touch on later, is that such disputes are not necessarily public. There are over 2,600 bilateral investment treaties around the world, in addition to a number of multilateral investment treaties. It's increasingly common for companies to consider their investments in the light of what treaty protections are in place. When will investment treaty protection matter for a construction project? Well, let's consider briefly the following example. A construction firm based in one state, the home state, invests in a foreign state, which is called the host state, and these two states share a bilateral investment treaty. One common issue that occurs is that the foreign state will then pass national legislation which cancels or modifies the contract and goes against the interests of the construction firm. The foreign state might also interfere with completion of the project and the firm's performance of the contract. Further, the foreign state may breach the contract or expropriate, simply taking possession of the project in its entirety. So now we turn to the following question. What protections are offered to my investment through these investment treaties? At the outset, I should point out that civil engineering and construction projects have been held to be protected investments under the definition of bilateral investment treaties and thus fall within their protections. Let's consider some of the specific key protections commonly found in investment treaties. The first provision I look for is whether the investment treaty in question provides an investor with a direct right to arbitration against the state in the event that the state breaches its obligations. BITs commonly contain this right, and the most frequently designated forum for the resolution of these disputes is ICSID. Some treaties, however, do not provide for direct arbitration, and therefore an investor must apply to its home state to bring the arbitration on its behalf. A second key protection is the no expropriation without compensation provision. This is perhaps the most critical protection offered by investment treaties, and it obliges the home state to compensate foreign investors in the event of an expropriation. That is, states must compensate you if they take your property. It is important to note that investment treaties do not prohibit expropriation as such. Rather, they generally require that expropriation be for a public purpose and be non-discriminatory in nature, and that the state must in any event pay adequate compensation to the investor. The final protection that I'll discuss at the moment is fair and equitable treatment. Nearly all investment treaties also require host states to accord fair and equitable treatment to foreign investors. The concepts of fair and equitable are a bit ambiguous and leave room for judgment and interpretation. Generally, it has been held that this obligation requires states to maintain stable and predictable investment environments consistent with reasonable investor expectations. The fair and equitable treatment standard might be violated as set out in the following example. An employer is told by governmental authorities that it will have permission to construct a project if it complies with certain requirements. The employer complies with those requirements. The employer then acquires the land, labor, and machinery to begin the construction works, and then the authorities deny the employer a permit to undertake the works. This can be argued to be a breach of the FET, or Fair and Equitable Treatment Standard. A number of other protections are commonly afforded to investors, which I'll set out briefly, but I won't go into detail. These would be the Full Protection and Security Standard, No Arbitrary or Discriminatory Measures Standard, and the National and Most Favored Nation treatment. About this final point, I'll just note that in some cases, the Most Favored Nation clause may allow investors to use clauses and import protections that are available in other BITs, even if they're not available in the treaty between the two states. An investor may enforce these protections by bringing a claim against the host state. Alternatively, the threat of such arbitration may itself be helpful in deterring detrimental state actions, or may be a productive tool in reaching a settlement. So we've been introduced to investment treaties and have seen how they may protect foreign investments. But you may now be asking yourself, how can I apply this in my own construction contract? As you know, some construction contracts, such as FDIC contracts, already have their own dispute resolution mechanisms. An investment treaty is not part of that. Well, the answer is this. A claim under an investment treaty can be brought in conjunction with, instead of, or after a claim under a construction contract. I'll look at these briefly in the following statements. In conjunction with. Assume you are a foreign contractor on a state-run project, and there is an investment treaty between your home country and the state where the project is located. The state entity has terminated the contract and expelled you from the site. You initiate DRB or DAB or arbitration proceedings under the FDIC contract. But the state entity has also violated certain protections in the bilateral investment treaty between the two states. You may therefore be able to initiate arbitration proceedings under the investment treaty at the same time as your FDIC arbitration proceeds. These would concern two different issues. The FDIC proceeding would deal with breaches of the FDIC contract, while the investment arbitration would deal with breaches of the investment treaty. Instead of. Assume the same scenario. You may decide that the events leading to termination and expulsion constituted breaches of the investment treaty. Instead of proceeding with the dispute resolution mechanism in the FDIC contract, you may decide to initiate arbitration under the investment treaty only. Again, this proceeding would not be for breach of contract, but for breach of the investment treaty. And finally, after. Assume the same scenario. You proceed with arbitration under the FIDIC contract against the state entity and you win. You then attempt to enforce the award in the local courts. However, if there is difficulty, if the local courts are corrupt, and annul the arbitration award, the FIDIC one, simply because it was rendered against a governmental entity. You may then be able to bring arbitration proceedings against the state under the investment treaty for the denial of justice by local courts. As I've hopefully made clear, in order to bring an investment arbitration, you will need some sort of action by or on the part of the state. This condition can often be satisfied in construction projects where state-owned entities or instrumentalities are involved. It should also be noted that ICSID investment arbitrations, unlike most contractual arbitrations, are public. This does not mean that the public has access to the case itself, such as the pleadings, oral arguments, etc., but the existence of the action is public. It is also common that the award resolving the dispute is also made public. This is one of the key differences I alluded to earlier between the ICSID arbitration and UNCITRAL arbitration. And UNCITRAL arbitration will be more open to the parties to leave non-public. It will be important for any investor considering bringing an investment treaty claim to evaluate a number of gateway or procedural issues. One of these is whether the asset in question meets the treaty definition of an investment. As you will see from the two sample definitions on the slide, construction projects typically qualify as investments. An investor must also meet the nationality requirements of the treaty in question. One common approach is for investors to structure their investments strategically in relation to the treaty protections available. Tribunals have allowed for the use of special purpose vehicles to obtain treaty protection as long as any such structuring takes place before a dispute arises. And if you'll indulge me, I'd like to read out a brief quote from a recent case that supports this position. The recent decision on jurisdiction in Mobile Corp v. Venezuela, the tribunal considered such structuring practices to be quote-unquote perfectly legitimate, at least in relation to future disputes. This is the passage as follows. The tribunal said this: the aim of Mobile's restructuring of their investments in Venezuela through a Dutch holding was to protect those investments against breaches of their rights by the Venezuelan authorities by gaining access to ICSID arbitration through the BIT. The tribunal considers this was a perfectly legitimate goal as far as it concerned future disputes. With respect to pre-existing disputes, the situation is different, and the tribunal considers that to restructure investments only to gain jurisdiction under a BIT for such disputes would constitute, to take the words of the Phoenix Tribunal, an earlier case, an abusive manipulation of the system of international investment protection under the ICSID Convention and the BITs. So the point is, gateway requirements must be met before the dispute arises. Further to the above, I note that all treaties differ, sometimes in significant respects. An investor must closely review their options and the treaties potentially available when considering a claim. The following slide demonstrates the anatomy of an investment claim. As you will see, the BIT between the two states permits investors of either state to bring a claim against the other state. In this slide, we actually mirror a recent claim by Kazakh investors against Uzbekistan. This is the claim by Visor Group, a Kazakh private equity fund against the state under the BIT between the two countries. The case is called Vladislav Kim and others v. Kazakhstan. The next slide illustrates the option of structuring through an SPV, which is often a Dutch company due to the attractive tax legislation and high number of treaties to which that country is a party. This slide shows the proportion of ICSID arbitrations brought under the various treaties, under the various instruments available to investors. As you can see, over 60% of these cases are brought on the basis of a bilateral investment treaty. A relatively high proportion, 20%, are also brought under specific investment contracts entered into directly between the investor and the host state. The investment law of the host state also provides recourse to investors in some instances. You also see a number of ICSID arbitrations brought under multilateral treaties, such as the Energy Charter Treaty. This slide shows the breakdown of ICSID arbitrations by industry or sector. The oil, gas, and mining sector represents the largest proportion at 25%. Other industries, such as transportation and electric power, make up the next highest proportion. The construction sector currently represents about 7% of ICSID arbitrations. However, as we've discussed, this number is likely to rise as more investors make use of the tools available to them. On this slide, I give a few examples of investment treaties in Russia and the CIS region. As you can see, the coverage of investment treaties is fairly extensive. For example, just by looking at the first line, we can see that investments from French, German, Lithuanian, Mongolian, Kazakh, and UK investors are protected within Russia. Therefore, if a Kazakh construction company is building a power plant in Russia for the government, and the Russian government fails to comply with its obligations under the Russia-Kazakhstan BIT, the Kazakh investor may be able to bring an arbitration against Russia. On this slide, I provide a few examples of disputes under construction contracts that have led to arbitrations under investment treaties. Given my time constraints, I'll address only two examples briefly. One is the second bullet on the top, ATA v. Jordan. This case involved a Turkish construction company employed to construct a dike at a site on the Dead Sea, excuse me. The employer was the Arab Potash Company, an entity controlled by Jordan. After the dike was constructed, it was handed over to the employer. The employer filled it with water and the dike collapsed. A dispute arose between the contractor and the employer as to which entity was responsible for the collapse. The employer commenced FIDIC arbitrations against the contractor. The tribunal found that the contractor was not responsible, and it also upheld, in part, the contractor's counterclaim against the employer. Unhappy with this result, the employer then applied to the Jordanian courts to annul the award. The Jordanian courts did so, and in the course of annulling the award, held that the contractor's right to arbitration was extinguished. This is exactly the situation we were discussing earlier. The contractor then initiated ICSID arbitrations under the Turkey-Jordan Bilateral Investment Treaty and won. The ICSID tribunal held that the decision of the Jordanian courts in favor of Arab Potash Company, a company controlled by Jordan, was improper and breached Jordan's obligations under the BIT. Another example I'll discuss briefly before concluding is AIG v. Kazakhstan. This is the first bullet on the second part of the page, the slide. The arbitration was brought under the US-Kazakhstan BIT, and the two claimants were AIG, a US company, and Tema, a Kazakh JV between AIG's SPVs and a Kazakh company. AIG indirectly owned 66% of the Kazakh JV and had all the voting rights. The investment concerned was a project for the construction of a residential housing complex. After approvals had been granted by the Kazakh authorities and construction had commenced, Kazakh authorities ordered for the project to be cancelled and for the land on which the project was being built to be transferred back to the government. The claim concerned, inter alia, expropriation of land and the capital which AIG had already provided, and the land was owned by the Kazakh JV. So this is an example of the investment treaties that can be used in construction disputes. Unfortunately, that's all the time I have for today, but hopefully I've conveyed to you the importance of investment treaties and how they can be an effective tool in your legal arsenal. And of course, I'm happy to take your questions. Thank you.
Большое спасибо. Если у кого...
Thank you so much. Should you have any questions, please raise your hands. We still have another speaker and no timer at all. Grand law firm. The representative of this company will tell us about his practices in China. Please be very brief. We don't have time at all left.
Firstly, I'm very glad to be here to share our information and experience. Other speakers speak about the Russian issues in the construction and the development. So now I'm speak some different. That's the Chinese experience. Eventually, there's some experience could be useful for here, because the China is quite similar with the former Soviet Union. In China, in the past maybe 40, 50 years, the most housing is allocated by the companies, by the government, not by the commercial buying. So the start line is very similar, I think. Eventually, my housing, I mean my parents' house, is former Soviet Union style. Fortunately, it's very useful anyway. It's built 60 years ago. 60 years ago. So I'm coming here, it's quite familiar with the house in the Moscow and St. Petersburg. Very familiar. Of course, that's not enough, because China, like you know, is developed quite fast in the past 30 years. But the housing, I mean the personal use housing, it just started about 15 years. 15 years. So urbanization just really started from 15 years. So that's really need by the people, because as you know, China has a 1.3 billion people population, and we have 400 cities around whole China. So the construction, the housing is really need for the peoples. But how they are to finance for such kind of housing? Of course, the first one is there's a bank loan. Okay, so the construction company or the developer to borrow the loan from the banks. Of course, there are some requirements. Firstly, the developer must have their own money for the project, at least 30% capital. And the other one is they have to complete the project 25%. Then they can get the money from banks. Of course, the bank loan is not only the financing method for the developer. They can borrow the money from a trust company. The trust company, maybe you can call that a mutual fund. The trust company can make a trust products to collect the money from the individual or institution and use the money for the loan to the developer company. Also, they use the PE method. The PE company collect the money to use for the some project development, and of course also collect from the money from individual and institutions. Also, if some company, like a big company or very profit company, they can lend the money to such developer. Of course, they are not a bank, they are not a financial institution, but they cannot directly to lend to the developer. They use they call the untrusted loan through the bank. They give the money to the bank, and the bank to lend to the developer. So they can get the developer can get the money through the many ways. So there's quite useful for the developer to make a lot of development. As a result, the developers in China is quite wealthy. Quite wealthy. They are developed very good because the market need is quite big, and the personal, to to buy the house, they are very aggressive to buy that. So in the past 15 years, they almost every house built was almost, a lot of things is sold. So for most developer in China, they are very beneficial. They are very good. Of course, the housing industry become a very strong and major industry for the China economic development. So right now, the developer has become very strong. Of course, developer and the civil engineering company not only participate in the housing, they also attending the road building and airport, a bridge, and they will become very strong. How strong they is? The 52 companies, the construct companies and the civil company become the ENR 225, the most strong civil engineering company, so list up on such a level. So right now they not only construct or engineer in the China market, they go abroad, even come to Russia. As I know, there are two projects going on in the Russia. One is in Moscow. They call the Federation Building or Federation Tower. That's a Chinese company participated in that project. And another one is here. They call the Baltic Pearl. The project name Baltic Pearl. They also, the Chinese company, come here to participate in the project. So right now, they can, as I saw, they probably bring the money to come here to participate in this project and cooperate with the Russian companies to build that, to participate in a lot of a project. Okay.
Спасибо большое за интересное.
Thank you so much for your informative statement. Any questions, please? From the point of view of construction, your statement was very informative. I liked it very much. What about mortgage instruments in your country? Do you have such a practice?
The personal, individual, usually to use mortgage to buy in house. So the bank to lend money to the personal. Of course, the individual must pay the down payment first, and then to 20-30% for down payment.
Спасибо большое. Если...
Thank you. Other questions? Otherwise, we have to wind up. So this is your last chance. I see there are no more questions. May I take this opportunity to thank our panelists. Thank you for attending this meeting. And have a good day.